an independent agency that serves as an administrative court. It is tasked with providing a fair, efficient, and effective system to manage and resolve administrative litigation for district residents arising under DC law. OAH is supported by the Advisory Committee to the Office of Administrative Hearings and the Commission on the Selection and Tenure of Administrative Law Judges. The Advisory Committee has 8 members and is tasked with identifying issues related to administrative adjudication and making recommendations for improvements. Cost is established by law to appoint, reappoint, discipline, and remove OAH administrative law judges. It's no surprise that OAH continues to face challenges with its massive increase in caseloads, staffing issues, processing cases in a timely manner, and online accessibility to cases and final orders. Some of this, of course, has been exacerbated by the COVID-19 pandemic. I thank OAH for their responsiveness to this committee's request for information, and I look forward to hearing more about the challenges the agency faces so we can help them work through and build on that foundation to meet their mission. We'll be hearing specifically from the Chief Administrative Law Judge, Colleen Curry, and Betsy Cavendish, the chairperson of the Advisory Committee. I also look forward to hearing from both government and public witnesses about the back-end management of OAH and DC residents' front-end experience with the agency. We value your input, and we're grateful for all that you do for district residents. Just some logistical announcements for today's hearing. Witnesses, we have only one panel of public witnesses, so I'm going to give everybody 5 minutes to provide oral testimony should they need it. If you are being called later as a witness, you're currently in the webinar mode. We will promote you when it is your turn, and then you'll have access to your camera and microphone to activate those for your testimony. If you have any technical difficulties, you can send a message to the host labeled as Committee on Human Services. Do we have somebody labeled as Committee on Human Services? Nope. We don't, because we are the Committee on Public Works and Operations. But who do we have? All right, send a message to the panel. And then we will follow up with you. And if you're having any trouble gaining access to the Zoom and you've pre-registered, you can reach my team at 202-741-2111, and they will try to resolve your issue. All right, so we are going to go ahead and move forward with public testimony. Our first and only panel includes Danielle Burrs, Senior Policy Counsel at the Council for Court Excellence, Sam Farber, Fritz Mulhauser, co-chair of the DC Open Government Coalition, and Michael Syndrome. I'm also going to ask any participants who've joined through Zoom who would like to give testimony but did not sign up. I don't think we have any actually in there, but if so, raise your hand. We're happy to promote you to this first panel so that you can give testimony. All right. So we'll begin with Danielle Burrs.
Great. Good morning, Councilmember Nadeau and staff. Thank you for the opportunity to testify. I'm sorry, was that my beep or your beep?
That's you.
Okay, great. My name is Danielle Burrs, and I am testifying in my role as Senior Policy Counsel for the Council for Court Excellence, or CCE. CCE is a nonpartisan, nonprofit organization with a mission to enhance justice for all in the District of Columbia. For over 40 years, CCE has worked to improve the administration of justice in the courts and related agencies in DC through research and policy analysis. Please note that in accordance with our policy, no judicial member of CCE participated in the formulation or approval of this testimony. This testimony does not reflect the specific views of or endorsement by any judicial member of CCE. Thank you for this opportunity to present our organization's views on the Office of Administrative Hearings, OAH, fiscal year 22-23 performance. We are very lucky that our new chairperson previously served on the committee with oversight of OAH, so we'll provide less background than we might otherwise. Over the years, OAH's jurisdiction and caseloads have grown, which increases the importance of its role in ensuring a fair and robust administrative adjudication in the district, though that hasn't always been matched with additional funding. In 2016, CCE developed a report on behalf of the DC auditor, which made a variety of recommendations for the continued improvement of OAH. That report is linked in the footnotes of my written testimony, and a summary of those recommendations is attached. We and others have continued to testify about opportunities to meet two of the needs identified in our 2016 audit. One is the need for online access to OAH case records, and the second is the need for greater investment to ensure meaningful and effective participation in OAH proceedings by pro se litigants. We appreciate the dedication that the committee has shown going into detail in its report on the fiscal 22 budget regarding these and other potential improvements, committing to fund them, making a detailed request for a benchmark study, and by taking the time to meet and discuss potential improvements during the fiscal 23 budget process. Over the past year, we were pleased to note that OAH launched a limited e-filing portal, made revisions to its website intended to improve user experience, and made some new hires. OAH has not yet filled all of its vacant positions, including needed IT staff and an independent cost staffer. We are happy to hear that they have recently contracted with a vendor for the baseline study required in last year's Budget Support Act. But we still haven't seen movement on a searchable database of final orders. We gladly offer to consult and collaborate with OAH's excellent administrative law judges and seek opportunities to assist OAH in effectively serving the district. Today, CCE urges this committee to help broadcast to the public the steps forward OAH has made and what more can be done through funding, staffing, and planning to ensure that any new or outstanding opportunities are embraced as quickly and effectively as possible. We would be very happy to meet with you, members of the committee, and staff to support that work. Regarding online access to case records, the OAH Establishment Act requires that the office make all documents filed in any case before the office available to the public for review. The DC FOIA adds the requirement that final orders be published on the internet. Unfortunately, OAH has lacked the necessary funding for the technology and staffing to meet these legal obligations for years. And I won't get into depth on that because I know that my co-panelist will. As for assisting pro se litigants, OAH proceedings can be complex, and hearings are both vital and intimidating for most litigants. Thousands of DC residents pursue cases regarding the denial of benefits they need to survive without legal assistance. This frequently equates to a lack of meaningful participation. Stakeholders have reported that OAH's Acting Resource Center Coordinator and updated website have been useful. CCE commends OAH's ongoing collaboration with the legal services community and support of the OAH Legal Assistance Network, OLAN. Unfortunately, these fall short of what is needed. It will be critical for OAH to move forward with plans to hire a full-time permanent Resource Center coordinator, continue to expand services, and bring on additional staff. In addition to robust funding, OAH needs a clear and consistent authority, as well as predictable funding. In 2016, we raised the concern that OAH's reliance on memoranda of agreement or memoranda of understanding for adjudication of matters from several agencies creates the impression, if not the absolute risk, that a contracting agency that disagrees with OAH's rulings or findings will terminate OAH's jurisdiction. So we look forward to working with you on that as well. And there's a little more detail about a bill that a past iteration of this committee put forward and that the council supported, but was unable to find funding for. So thank you for your consideration, and I welcome any questions.
Thank you very much for your testimony. We will now hear from Sam Farber.
Hi, Brianne. Thanks for having me. I wanted to chime in on my experience with a OAH matter that was routed through DPW initially. Sometime in August, I received a notice of violations saying that there was excess refuse on my property and that I was going to be fined for not removing it promptly. It was clear from the notice of violations and a cursory glance at my property that the photographs were not of my property. So I promptly submitted the formal denial of responsibility for those for that refuse, and had a OAH hearing scheduled for maybe 2 months later. No, it must have been in November. So that hearing was scheduled for November, perhaps towards the end of the month. In any event, I followed the procedures that were listed in the mail that I received and in the online materials to submit a motion for dismissal. The motion, I am not an attorney. The motion for dismissal was certainly a little bit complicated from where I was sitting in terms of the various requirements that had to meet, like specific mandated layout and whatnot. I had the good fortune of being able to solicit the assistance of my father, who's a retired attorney, and I live in a 2-unit. I live in a condo in a 2-unit home, and the downstairs neighbor, who was also my witness, testifying that in fact the pictures were not of our property, is also an attorney, and so was able to help me with that. Without that assistance, I can only imagine how complicated it would have been for me to submit my motion to dismiss. In any event, submitted my motion to dismiss in, I believe it was October 21st, and I know that my hearing wasn't at least until a couple of weeks into November. And ultimately, I received notice a couple of days in advance, perhaps, that my hearing was postponed until December. No problem, I figured, more time to review the motion to dismiss and hopefully not even get to that situation. That never happened. The day of my hearing arrived, and I showed up promptly for the 9:30 call. It got to be 9:40, and I emailed the clerk who was assigned to my case and asked, my concern was, am I in the right place? Did I make some kind of mistake? The clerk assured me that I was in the right place and to just hang on a moment, that the judge would be there shortly. I sent 3 more emails to the clerk over the course of the next 2 hours, none of which received a response. The third and final email was sent sometime around 11:30, at which point I said, I will be hanging on the line until noon, and then I will be getting off because I am not, I don't need to spend my whole day on hold with no one showing up for the hearing. So noon came and went. I got off the hearing, or I got off the Zoom for the hearing, and immediately after that received an email from the clerk saying something along the lines of, apologies that you encountered technical difficulties. Please work with the office to reschedule the hearing. I made clear to him that I was present for the hearing and that I would not be rescheduling it. That was not my obligation. At that point, I learned that the judge would just be simply adjudicating the matter before the end of the day without any additional input. Obviously, I was concerned that I was going to be called upon to pay a fine that was just baseless. Ultimately, I received a positive adjudication in my regard, in my favor, where I didn't need to pay any fine. Although the adjudication did say that I wasn't present for the hearing, which I took issue with, but I got the result that I wanted. In any event, the whole process was very poor, from the notice of violations in the beginning that clearly had nothing to do with my property, to continued lack of communication and response from OAH, to ultimately not showing for the hearing that I prepared, a variety of exhibits and materials for in advance. So that's kind of the spiel, right in under the gun, it seems, on the timer. But if anyone has any questions, I'm happy to answer.
Thank you very much. Fritz Malhauser.
Good morning, Council Member. I'm Fritz Molthauser. I'm co-chair of the Legal Committee of the DC Open Government Coalition. We've testified before you in earlier committees, and it's a pleasure to see you again taking on new jurisdiction today, Office of Administrative Hearings, and we'll look forward to being back in a few weeks to talk about technology as well. Nothing could be more crucial, and today's hearing underscores that, and we count on your good guidance over the district's technology policy. We're here today to talk about people. Thousands and thousands of DC residents are like Mr. Farber. They need some help getting a situation resolved with a DC agency. And the questions we hope you will ask: can people with questions about their cases get prompt information? Can a person considering a case find out what it's like to do this? And can you learn what has happened in past cases like yours? And we've been raising those questions for some years. And today, I'm unfortunately sad to be here to say it's still not that great. The most general concern, I think, jumps out of the pre-hearing answers. The agency is drowning in cases. It's overwhelmed by numbers of cases, and there might be individual trash tickets, but each one is a person. And 20,000 new cases arrived last year. They managed to dispose of 19,000. The backlog is 13,000. That is just huge. And even their FOIA responses take too long. The agency expresses in every other page its anguish at overwork, turnover, stress, and the like on judges, legal staff, and others. And that cries out for attention. It's welcome that the staffing study, which your council colleague directed in last year's committee report, is finally getting started. He asked for it to be done to help this year's budget, but it didn't happen. But it's getting underway. At least they say there is a procurement. So that's a good news sign, because the staffing situation is clearly urgent to understand and analyze what's the work, how should it be best done, and what resources will be needed. On open government issues in particular, let me touch briefly on four. Danielle started those discussions as well. There are no published orders yet. That is, the decisions of this court are secret. No one can read them, and that's been the case for 20 years. They were told years ago that this violated the law, and here we are today with no solution. The office says they are talking with vendors, but they've said that for years. So pardon my skepticism that we're moving quickly. And they haven't reached out, as Danielle said, to experts and users to help with the design of the system. And they've even sent up a signal in this year's questions that the access to opinions won't go backwards. It'll only be going forward, and it won't be in all their jurisdictions. And those decisions are very significant and need more ventilation, in my opinion. Courts all over the country are dealing with the question of confidential information, how to make records accessible while safeguarding privacy interests. This is not a new problem, and we just need to get good solutions on board rather than say, oh, we can't do it. Second, there's no electronic filing yet across the office. That means the electronic case file can't start until cases begin with electronic filings, as we know in the federal system and in other courts, Superior Court and the Court of Appeals, long since having moved to electronic filing. But only one area of the OAH allows that, and they say they're moving towards more. But again, that's the kind of response that we've heard for so long that we're working on it. And this is urgent to get an electronic data system for cases. Third, the help function is grievously under-resourced. There was a person in charge of a resource center. We understand that that person doesn't work there full-time. your council added another staff member, doubling the resources, and that person, we understand, isn't there all the time. What's going on here? And it should not be a question of anxiety that they're improperly offering legal advice. That is not a reason to not be helpful. And fourth, the technology area. As in so many agencies now delivering services and managing operations through information technology, tech is their lifeblood. And they said for years, we don't have enough people to manage our courtroom technology, our case management technology, and so on. And your council added 2 more tech staff to this heartfelt plea, and they don't have them. But these were the most urgently wanted staff that they asked for to help with tech challenges. And so here we are 7 months in without the resource that the council provided. Please ask the obvious questions here. How are we doing getting these things up and running? What is the serious schedule for accomplishing things that are said to be in progress? And when will the citizens of the district, like Mr. Farber, have a competent response to case questions and their need to get a little problem resolved? OAH can do this, and we look forward to your leadership in helping them stand up to the challenges. Thanks so much.
Thank you. I'm just going to check one more time to make sure our 4th witness hasn't joined the attendee list. Does not seem like he has called in. So we will just proceed with questions for this panel. Thank you so much for your testimony. I'll start with Ms. Burrs and Ms. Mulhauser. Ms. Burrs, what are you seeing in other jurisdictions regarding publishing the final orders and making that information available to the public?
That's a great question. And actually, if you don't mind, I'll defer to Fritz for that one, because I know he has a great depth of specificity he can go into.
It's commonplace. For example, federal rules for Medicaid require public access to opinions. You can go today to the state of California Administrative Hearings Office and read opinions about heart-rending medical problems, and the confidentiality isn't compromised. The details are masked, but the opinions are there. This can be done. It's commonplace elsewhere.
And what's the value or importance of having these opinions online in terms of precedent for people who are arguing cases before OAH, for either of you?
They're obliged to do it by DC law, so the importance is to obey the law. It wouldn't be cheerful to say, well, we can't obey the law.
No, let me try that again.
The value for the user.
For the user, if you're going to argue a case for OAH, what's the impact of not having past decisions available to you?
I think many users could be comforted to see a page or 2 opinion about a trash ticket or a school suspension, which shows that judges dug into the facts and issued a wise decision. And that would help them understand the facts that are important, how to present things, and that this adjudicative office is there to help. It builds confidence and it shows how to proceed.
Go ahead.
Sorry, council member. I would just add to that, it's really difficult to craft an argument if you don't know what the boundaries that are acceptable are, and that's what you would get from final orders.
Right. Okay.
It's especially true in areas where attorneys are representing people, that attorneys. I worked for 5 years at Legal Counsel for the Elderly as a volunteer, and they were before OAH all the time. But imagine not being able to see prior orders in areas of Medicaid, for example, where they were litigating every other day. So for attorneys, it's especially troublesome not to be able to see opinions. But there's an underground, of course, that scares them. But the office is obliged to do this, and people can use them valuably, and it's time to get on with it.
So another thought I had around this is just, so presumably that the judges have access to the decisions that have been made in some form.
Yeah, there is an internal information system.
So judges can rely on precedent when they're making their decisions if they wish to do so, but the public can't do the same because it's not available. Okay.
And as with any courthouse, another judge down the hall issues a decision. It's not binding on her colleague in the next office. But since many cases present common issues, the mode of analysis is terrifically important to see how the court breaks down the problem, and which parts of the problem are significant, what evidence is most helpful, and so on. So even if the decision would not be binding on a future case, the mode of analysis tells everyone, here's how the court does its work.
Right. And the other area that I feel like it might be important is in guiding government agencies around their work, right? So Mr. Farber's case is something that I hear about all the time. If you can look at all of the cases and all of the decisions and see that, you know, DPW has been issuing tickets for people about illegal dumping and it happens to be wrong all the time, then that's something that I think DPW leadership needs to know about, and you can correct things upstream if you have a way.
Well, the question of OAH ability to guide the executive to do better is a fascinating one. And the Court of Appeals recently said, yeah, they really can. The judges have hesitated, and the mayor hates the idea, of course. But yes, piling up problem cases and showing this is big, you all ought to pay attention to it. That's a very valuable use of accumulated cases. Agencies, of course, can look into OAH database. They say that in their question answers. Major agencies have access to their files. The public doesn't, but the agencies do. So the agencies would, in your hypothetical, you know, they have no excuse for not knowing the run of decisions, repeatedly throwing out wrongly issued tickets or whatever, because they can see those results anytime. It's the public that can't see.
Which gives us, you know, a deficit in terms of, you know, watchdogs or council oversight, you know, because someone like you, Fritz, might look at that data and say, hey, Nadeau, have you noticed this agency keeps getting its NOVs overturned?
Absolutely.
We should do something about it. Surely the legislative branch is sometimes more interested in this than the executive is, and that's an important part of our checks and balances. But if we don't have the information, then it's harder to do that. Or if we're relying on FOIA requests, for example. So very helpful. Anyone have experience with which cases most often see folks retaining counsel to argue them versus doing them themselves?
I can definitely follow up on that.
Great.
I usually talk about it in the reverse, who's most likely to be self-represented. And so I have to make sure I'm not misspeaking, but I'll definitely get that to you.
Mm-hmm. Makes sense. Well, who is most likely to self-represent? Remind us.
Well, in broad terms, it's lower income folks and Black and brown folks who are most likely to be represented across all categories of cases. So that's why we focus there.
Yeah. And
The Access to Justice Commission has an unhappy history of trying to ask both the courts, Superior Court and all its branches and the Court of Appeals, about representation status when they write their every 10 years a report on access to justice. But they, with much heavy lifting, trying to get the numbers, since it's not regularly captured, they've reported for decades that 80% of people in courts are not represented, and that's a very persistent number across many jurisdictions in DC and elsewhere. So the basic number is huge.
So to Mr. Mulhauser, you talked about the staffing issues at the Resource Center. How do people typically use the Resource Center? Can you walk us through that?
I think it's quite unstructured. They call up or they walk in. There's a room which people are directed to when they come to the reception area, and if there's someone there, they can sit down and talk to someone. And over the years, that has waxed and waned with the richness of information available. There have been years in which law student volunteers were available, trained and supervised by the staff. Other years in which written materials in various languages were available. And they talk about doing more of all that. But the plain situation now is that they have only 2 not full-time people. And the council looked into it in depth and said, 2 people full-time, do it. And they don't.
Mm-hmm. Mm-hmm.
So on that topic, it seems like there's not a designated home for the Resource Center in the OAH architecture. And so right now, and in the past, at least one attorney advisor in the past and one currently are under Office of General Counsel, whereas any additional staff they're working with are in operations. And so they're reporting to different people, they have different goals. I think the individuals are doing the absolute best they can to execute their jobs well, and we've certainly heard that, but it's a challenge that I think doesn't need to be there.
Okay.
The attractive model, which the OAH leadership has repeatedly said to the legal service community, is do what Superior Court has. The bar should arrange for attorneys to be there and be helpful. So they would love it if there were an easy solution that someone would walk up to their door and offer. And that has not happened. But they also don't have the full-time dedicated staff to oversee some volunteer provision of help. So the question is priorities. And it seems to outside observers that helping the thousands of people using your office every year should be a stronger priority than this confusion of, is so-and-so available this month or is so-and-so not available this week? There is just not a consistent provision of skillful help in the Resource Center. There's a very long-standing argument about whether it has to be lawyers doing it, and there are different views about that. My own is that you can be helpful without being a lawyer, without breaking the law. But that's not a conversation that we've ever been able to get very far on with the agency because of the very, very strong fear by lawyers that someone will say incorrect things who is uninformed and will hurt the customer. So that's another conversation. If you have to have lawyers giving the help, that of course makes it much harder to do because those people are scarce. Law students can do it, but anyway, who needs help, how much, when, and how to provide it is just a big, important conversation, and it's moving slowly.
Yeah, there are definitely law students at several local law schools who are interested, or their professors are interested and ready to step in if there's an opportunity. It would also be a lot easier to get practicing attorneys to provide pro bono if there were a better way to access precedent.
Right. Thank you. I'm going to turn to Mr. Farber for a minute, and then our fourth witness actually joined us. So we'll go to him. But Mr. Farber, can you talk about, do you happen to have handy information about the notice you received about appealing before OAH, and what options you had going through the hearing or admitting, or all of the options that?
Let me check my records right now to see if I have anything there. I mean, part of the problem with that is I only received paper copies of these things. So I don't have anything to, I think once I got the decision that I wanted, I was okay to get rid of the notices. But I know that when I received the notice, my options were to admit or deny, and admitting came with paying some sort of fine, and then once the hearing was scheduled, that wasn't an I mean, I had the option to not show up and just not plead my case and pay the fine, but my only alternatives were to show up for the hearing or to attempt to, I don't even know that it prompted me to submit a motion to dismiss. It was probably my father who was like, you didn't do this. A motion to dismiss is what you file in this, scenario. So, like, even if it said you can file a motion to dismiss, I certainly don't know what that means, and couldn't have done it appropriately, at least without legal guidance. And that's assuming that it did encourage me to submit a motion of dismissal, which I don't think it did.
And when you decided to move forward with the hearing, what information were you provided to indicate how that would go? I mean, was there any communication about, sometimes judges get backed up, you may have to wait? I mean, how did that get conveyed to you?
No, there was no logistical information about a backup or anything like that, or potential for the hearing to not occur promptly when it was scheduled. And then beyond logistics, there was no information about how I could expect the hearing to progress, like what would happen. I just had my motion to dismiss with all my pictures, and pictures being photographic evidence, and my narrative of what had transpired, and was going to do my best to recount that. So,
okay. So we'll talk with the agency a bit about that process for the public and what could improve it, and how to make things more clear, what other options you might have had, even though it sounds like it was not clear that you did, right? So we'll walk through that process on the record with the agency when we get there today.
Okay, yeah, that'd be great. I mean, it was, I'm sure I spent more than the fine was in terms of, time and effort to not pay it. But it was just like, I shouldn't have to pay a fine just to make something go away. That's not, that's not my fault or what have you. So.
Thank you.
Yeah, thanks.
We've also been joined by Michael Syndrome by phone. Mr. Syndrome, you have 5 minutes for testimony. I can let you know when you hit that mark if you are, because I think you can't see the terminal.
Morning, Madam Chair. Can you hear me?
Yes, go ahead.
Perfect. Disabled veteran served our country more than most. Michael Syndrome. Had technical glitch to connect with you, but Katie was unable to, of your staff, unravel it. So thank God I'm through. Couple things I wanted to share with you. On the street, Office of Administrative hearings, has a reputation to be hyper-technical, sad but true. The legislative intent is crystal clear. When a litigant is unrepresented, that means the government is to be unrepresented. And that's not the case. They piecemeal, and again, I proceed impropriety persona without counsel, and in motions and whatnot, which are really determinative of the case, they'll permit a battery of attorneys in social service case, specifically Medicaid with AmeriHealth. Right now, as I speak, Madam Chair, I'm writhing in pain, dental pain, and I can't get the care evidently I'm entitled to. My case is extremely complicated beyond the scope of garden variety vendors. I also require ozone, which none of them have. And so ordinarily that would call for a single case agreement. The problem is that they have no one that they're willing to bring in because it costs more. I have a treatment case from Dr. Gary Adams. It's rather pricey. Comes to like 30, rounded off, 37,000. Wayne Turnage is he came to the house. He took pictures. He indicated to Antonio Lacey and company, get this right, get it taken care of, I guess in preparation for this hearing. So it is helpful to have oversight. In the next, between now and budget, I'll apprise the committee to you what's going on. But they've done nothing. They have done absolutely nothing, and they just obfuscate. And the ALJs, too, don't seem to be very learned. I'm referring to Jeremy Elper and a Kimberly Cruz, constantly throwing hyper-technical curveballs. We don't get to the merits. And erecting motions hearing. AmeriHealth is very well represented by a big-name law firm, a number of lawyers. It's Epstein, Becker, and Green. And they're just out to crush my spirit without giving me the care I'm entitled to. It's been noted that I have full coverage and I should be receiving the care that I'm entitled to. But they simply would rather go through a rabbit hole and the Office of Administrative Horrors, hearings, and take that route to get the case squashed time and time again. And Court of Appeals, they drag their feet. It's an oversight of sorts, but it's all in the same club. I've tried, too, with OAH rules for a three-panel judge review. They don't even recognize it. And according to OAH rules currently, it exists. I'm going through here my papers to get you that rule. And also recusal. They indicate that you have to parrot the D.C. Court Rule 3I, bias or prejudice of a judge, recusal, and so on, when it says, whenever a party to any proceeding makes and files a sufficient affidavit that the judge or magistrate before whom the matter is to be heard has a personal bias or prejudice against the party or in favor of any adverse party, the judge must proceed no further, and another judge or magistrate judge must be assigned in accordance with Rule 40I to the proceeding. That's not been done, and I filed the appropriate affidavit, showed sufficient cause for recusal, bias and prejudice, and they've done absolutely nothing. On the one hand, they say we parrot the super court rules, but on the other hand, they don't. And again, this was with Kimberly Cruz, backing up with Jeremy Elper. I don't have what's required by law, a primary care provider. And Bennett Rushkoff, denied everything with prejudice. Even in spite of that, my primary care provider ordered a upright rollator and distilled water. The rollator came, distilled water is still not been received. And this was brought to the attention of the hearing, and so the judge said, well, it's not before me, and then the attorney, Smith, says, well, according to my notes, you got it. I'm telling you, I did not get it. And I want to get his name here, too, so you got it. But it make it Christopher Smith, and his partner here, sidekick, is Clifford Barnes. But it makes it inordinately difficult to get anything done. Backing up to notice of infractions. Previously, we had no heat here in the condominium. And so I reported it. They came out and cited me. We have central heating. So how can I be responsible when we have a boiler? Same thing with bed bugs. We have infestation of bed bugs here. So I received a notice of infraction disingenuously by the by Sylvia Bryant, the, Department of Buildings, D.C., who came in because we had no hot water, no heat. So she wrote me up here for failure of owner to take proper precautions to prevent insect reinfestation after insect extermination. Well, truth be told, that's part of the common expense to be picked up by the board, which we don't have. Totally out of control, too. But backing up to the heat, they phoned me and says, well, we made an error. Indeed, they did. Same thing with this notice of infraction about the bed bugs. So I've requested a hearing to contest it. I deny it. And that was done, looking right at it, on November 2022. Haven't heard a word. And it is case number here, 23 NOIR-INS-00126. Date of service, October 11, 2022. So clearly I'm within date, filing timely, haven't heard a word. And with respect to Medicaid, their hired gun, Fletcher, is a clown, is a joke, doesn't know what he's talking about. Ozone is a very beneficial substance, which Medicaid doesn't know anything about, and it costs more than the toxins and poisons they would want to use me as a pincushion. So this guy, Fletcher, says he was given a 20-minute crash course in medical school, and based upon that, now he's an expert. And I provided to the respective ALJ, Cruz, studies and from well-published journals that ozone is recognized, it indeed works, and totally disavowed, ignored. And remember, administrative law judges are not doctors. One thing too,
Mr. Syndrome. Hey there, I let you go 8 minutes, so I'm gonna have you pause there. Thank you very much for your testimony. So I'm gonna ask my team to follow up with you on the dental issue in particular. That seems urgent, and also was taking notes on these other issues for OH. So I'm really glad that we had you out here. Thanks for joining my new committee for the first time. It's great to have you.
Likewise. Let me give you the case for dental, Madam Chair. It's case number 22 DHCF 00124. Repeat, 2022 DHCF Department of Healthcare Finance -00124. I did sign up today for OAH, the committee, Office of an Advisory Committee to the OAH, and Commission on Selection and Tenure of Administrative Law Judges. I bring that to your attention because I do have access to justice for all DC, but my point is, when I have inquired about complaints, I'm referred to in-house to their general counsel. And no one has a clue about this Commission on Selection and Tenure of Administrative Law Judges, nor the Advisory Committee to the Office of OAH. So I'd like a little bit more about that, so to file a complaint. Not unlike in Superior Court, you got the Commission on Judicial Disabilities and Tenure, which in kind should be also with OAH. They play a strategic role in applying law and in public health cases and public benefit cases and so on, and they're not doing that. And so again, when I've made inquiry, and you know, I'm not one to sit on my laurels, Madam Chair. I've asked, I said, who do I defer? Well, you talk to us about it, in-house, the police policing themselves, and I'm going nowhere quick. So we need to get more information about this advisory committee to the Office of Administrative Hearings. I've asked your staffers about that. They said, bring it up now, which I am. And then the Commission on Selection and Tenure. And specifically, my query is, where do I file a complaint? And to who is it sent to? So maybe that would be helpful for us that are experiencing all of this this nightmare.
Yeah. Well, let us get back to you on that, because I'm still learning all of this too. But I'm taking this down, and I know my staff is as well. And we are going to hear not only from the chief judge, but also the chair of the advisory committee. So we'll get to some of this. Thank you so much for your testimony.
Yep. Thank you, Madam Chair. Hearing your voice. And you know, one thing about the veterans too, you were at the Winter Haven, but they flipped the script. It used to be the beginning of the year, And now it's like around Thanksgiving time. Were you there perchance?
No, that makes sense. No, we thought about coming at Thanksgiving, but we couldn't pull it off. I was wondering about that, but that's a good, yeah. So now we're gonna have to wait a little while to get to the next one.
And the thing of it is, they don't alert the veteran. You know, we're left in the dark. So my communication with the outside world is my landline and snail mail.
Mm-hmm.
And other than that, I'm not getting any kind of update, which ought not be. And I want you too, Madam Chair, to look at that OAH rule for in-bank review. It's still on the books. It's valid as I understand it. I'm trying to put my hands on it. I thought I had it pulled aside here so I can give you the specific rule, but they ignore it. And a lot of things too.
Well, let's ask Mr. Mulhauser on this panel while he's still here, if he knows anything about the in-bank review.
Sure. Thank you.
Sure. Thank you, Mr. Syndrome.
You're welcome, Madam Chair. Always a pleasure.
No, I don't.
You don't? Okay. Well, we'll get into it. All right. Well, thank you to this panel. We appreciate you very much. We are going to move to our government witnesses for today. Thank you. Great. We'll now be joined by Colleen Curry, Chief Administrative Law Judge for the Office of Administrative Hearings.
Good morning, Councilmember Nadeau.
Good morning. Before you begin your testimony, I'm going to administer the oath to you. If you could raise your right hand. Thank you. Do you swear or affirm under penalty of perjury that the testimony you are about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth?
I do so swear.
Thank you. You may begin your testimony.
Thank you. Good morning, Chairperson Nadeau, committee members, and staff. My name is Colleen Curry, and I'm the Chief Administrative Law Judge for the Office of Administrative Hearings. Thank you for today's opportunity to testify about OAH's accomplishments and challenges during fiscal year 22 and thus far into fiscal year 23. To describe OAH's current operational stance and the state of the agency at the end of fiscal year 22, it is necessary to begin by looking back almost 3 years. Prior to March 20, OAH conducted most of its business in person and created and retained most of its records on paper. The declaration of the COVID-19 public health emergency in March 2020 necessitated a dramatic and sudden change in OAH's operations. Over the course of 2 weeks, OAH moved from conducting nearly all hearings in person and creating paper files to conducting 100% of its hearings remotely and creating only electronic files. The agency continued that stance through most of fiscal year 21 and into fiscal year 22. As the district began to emerge from the COVID-19 public health emergency during fiscal year 22, OAH began evaluating those changes in the agency's operations that were necessitated by the public health emergency and applying the lessons we learned from those changes. In collaboration with stakeholders and following nationwide court management trends championed by national experts, we now conduct hearings in most of our cases remotely via audio conference by default, with the flexibility for parties to request to participate via video conference or in person. This process best allows OAH to meet its goal of affording the widest possible access to our hearings to all the communities we serve. While the vast majority of our hearings continue to be conducted remotely by WebEx audio, we continue to evaluate which methods best serve our constituents and to make adjustments as necessary. Perhaps the most impactful lesson learned through the public health emergency is that electronic, remote, and digital access to case filings, case records, case schedules, and hearings is preferred by most users and provides the most access to the widest group of the agency's stakeholders. Maintaining the current level of remote work and remote hearings and providing an optimum level of digital access has increased the agency's need for and our reliance on technology. Utilizing more technology and computer applications than before and in more rigorous and demanding ways has required us to evaluate both internal and external processes to identify the best methods through which we can meet the needs of this new digital norm. This evaluation of our processes has revealed that any improvements we could make are hampered by the state of our IT hardware. Much of it is antiquated, obsolete, or non-functioning, and users experience lags and delays or are unable to easily use necessary software, which in turn negatively impacts efficiency and productivity. These technological challenges are exacerbated by staffing issues and increases in case filings. In the last fiscal year, as was with the case of many district agencies, and indeed across the spectrum of both private and public sector employment, OAH suffered from a high number of employee vacancies. This was despite rigorous recruitment. As a comparison, at the end of fiscal year 21, the agency saw a 15% vacancy rate due to resignations, and at the end of fiscal year 22, the agency saw a 17% vacancy rate. High turnover and inadequate staffing levels have had a profound impact on all aspects of our operations. These staffing issues have an increased workload on remaining staff, required managers to devote additional time to train new employees, negatively affected morale in the agency, and have directly resulted in delays in processing and adjudicating cases. Compounding the effect of staffing issues are the increases in case filings the agency has seen. Prior to the March 2020 public health emergency, we were already experiencing a large increase in overall case filings, and a backlog of cases was building, particularly in cases filed by the Department of Consumer and Regulatory Affairs and the Department of Public Works. As a result of the public health emergency, we saw a dramatic increase in the number of unemployment insurance cases filed, and to best meet statutory mandates, we had to reallocate resources to address the resulting backlog in unemployment insurance cases. And we saw a 35% increase in total case filings between fiscal year 21 and fiscal year 22. For example, case filings from DCRA alone increased more than 62% between fiscal year 21 and fiscal year 22, from 4,939 cases filed in fiscal year 21 to more than 8,000 in fiscal year 22. And those cases have more than doubled since fiscal year 2019, when 2,981 cases were filed. OHH fully expects that the number of cases filed by the two successor agencies to DCRA, the Department of Buildings and the Department of Licensing and Consumer Protection, will at a minimum remain at this higher level. These increases, on top of backlogs caused or exacerbated by the March 2020 public health emergency, have cascaded into other jurisdictions. The confluence of these challenges facing the agency over the last few years manifests itself in the current backlog of cases, even though the agency is using those resources we have as effectively and efficiently as possible. In the face of these challenges, however, OAH has remained focused on successfully executing our mandate. That is, to adjudicate the cases brought before us as efficiently and fairly as possible, with the broader goal of providing the best service possible. That includes ensuring equal access to our hearings, continuing to identify ways we can remove barriers to broad participation in those hearings, and remaining attuned to the needs of the communities we serve and adapting to those needs where possible. We must also be mindful about stewardship of the public resources entrusted to us and engagement with our stakeholders, including the mayor and the city council, to respond not only to their concerns, but also to the needs of our litigants. During fiscal year 22 and to date in fiscal year 23, OAH has taken concrete steps to address those challenges I just spoke about. In particular, the agency began an evaluation of our current technological business processes to determine what hardware and software are necessary and how best to integrate each such equipment and software to provide the widest access possible in the most efficient ways and to meet the demands of the new digital norm. Additionally, OAH utilized the flexibility afforded to the agency by council with respect to the paid family leave funds by allocating paid family leave funded full-time employees to address case backlogs. While the paid family leave funded FTEs are primarily assigned to process paid family leave appeals, those positions have also been assigned to process cases in other jurisdictions that were experiencing or are experiencing backlogs, particularly in the UI, DCRA, DOB, and DLCP jurisdictions. And OAH is using the funds afforded by council to procure a staffing benchmark study to evaluate workload across all divisions to better inform the agency as to the appropriate staffing levels. In spite of the challenges of the last fiscal year, OAH has achieved some notable milestones. On August 22nd of 22, OAH rolled out the first phase of our e-filing portal, and on November 1st, 2022, we rolled out the second phase of the portal. This portal allows registered users to electronically file new cases in certain case types and to file additional documents in all case types. Before the end of the second quarter of fiscal year 23, we expect to roll out the final phase of the portal, which will open the portal to users filing new cases in all case types. Additionally, through careful allocation of resources and personnel, OAH completely eliminated the backlog in UI cases that had arisen as a result of the public health emergency. Notably, between November of 21 and June of 22, OAH closed over 1,600 unemployment insurance cases. And OAH has continued to revitalize the Resource Center. Of particular note, in collaboration with the Office of the Chief Technology Officer, OAH rebuilt our website to increase accessibility and ease of use. The new website launched on September 29, 2022. OAH's commonly used forms have been redesigned and rewritten in a way to increase accessibility. We have made the most current versions available in the Resource Center as well as online on our website, and have ensured versions are available in English, Amharic, and Spanish. OAH evaluated and improved the structure of its main telephone line call tree to increase efficiency and ease of use by callers. And the Resource Center, which had been closed during most of the public health emergency, reopened to walk-in customers in April of 2022. Ms. Chairperson, thank you for your time and interest in OAH. In closing, please allow me to publicly thank those who were most instrumental in helping me prepare for today's hearings. Chief Operating Officer Lachelle Jenkins, General Counsel Smruti Radkar, Administrative Officer Nicole Green, Staff Assistant Joseph Mangan, and the Agency Fiscal Officer team comprising Siobhan Smith, Ebony Temple, and Kimberly Pickett. I am happy to answer any questions you may have. Thank you.
Thank you very much. I want to start by going through some of the issues raised by the public witnesses today. I know you were here for that testimony. You mentioned some of your tech challenges. One of the hot topics today was about publishing final orders. Can you talk about where we are on that?
Yes, we are currently in the procurement process. We spent the last year evaluating options, including working with the Office of the Chief Technology Officer to create the database. Unfortunately, what their offer was to create yet another case management system for us, which we already have a very robust case management system. And so that wasn't going to work. And we've identified some vendors, had to present suggestions of ways internally that we can do that. And we are currently in the procurement process for that. We are hoping to have a vendor selected by the end of February and to go live with the initial creation of the project by the end of March. The goal is to have an online final order search available and to go live before the end of the fiscal year. And I say that's a goal. This has taken a lot longer than I would ever have imagined and hoped. It's been.
What do you attribute that to?
Looking carefully at how, what technology we need to do it, how to make it the most available as possible. And also just having so many technological issues that we have, and trying to carve out the time that we need to spend time learning about the process. It's just taken a lot of time.
You mentioned you have a really robust case management system right now, and Octo had offered you a different one.
They'd offered to create another case management system to use to support a final order search. And it's a little bit beyond my technological understanding, but I know that the bottom line was they wanted to create a new case management system that would work, that would basically work alongside our current case management system. And since we already use another case management system from DMV to adjudicate the Title 31 cases, having a third case management system just didn't make sense for us.
And you're trying to find a vendor now who will be able to help you put the final orders online from both the two systems you're working with right now?
For just our internal case management system, we don't have, once we're working with DMV to try to connect the ETIM system with our system. We're at the very beginning of our process with that. The goal is that those cases that are filed through the ETIM system would come into our case management system, and then those final orders would also be part of the final order search.
But the final orders won't be able to be public through your new system until that is completed?
For the Title 31 cases, not for the rest of the cases.
How many of the cases do you adjudicate are part of the Title 31 cases?
I actually don't know the number. I believe that right now there are, and I'm really ballparking here, probably 2,000, 2,100 cases that are pending adjudication. But I may be completely off with that. I don't know how many it is per year. Again, it's a different case management system, and we don't have a lot of data or access to pull the data that we need like we do our own case management system.
Mm-hmm. But it was a change in the law that pulled OAH into that system.
My understanding of this predates me is that the Title 31 tickets are part of the Civil Infraction Act, which we have jurisdiction over. And so we started hearing those sometime before 2016. I'm not exactly sure when. And it's been a rough ride. We've had issues with working with the case management system. And it's been very, very difficult and time consuming for us. And we've been working with DMV and their vendor. As I said, we're at the very initial discussions at this stage, but that's the goal.
Okay. And then once the final orders are published online, what is your vision for the public experience accessing those?
Our vision is that the public would be able to search through Boolean search, through some information that's tagged in the orders. They can do a word search, specific word search, a Boolean search, search for case types. So if somebody is looking for an unemployment insurance case and they want to know the decisions, they'd be able to go to this and look specifically for unemployment insurance cases. So there's data embedded in the orders, and then it's a Boolean search, and it's the goal is to have a very simple online search form that you would put in.
And how far back in time would the search history go?
Right now, we would start moving forward, and that's simply because since 2016, we have issued over 100,000 final orders. And we would need to evaluate which case types have to have information redacted and figure out a process and a workflow for redacting those before they're published to the web. And then also get individuals who would manage that process. And I understand that there is software out there that is available for doing this, but that still requires somebody to manage the project. So it would start moving forward, and then as we could figure out how to do that, who could do that, we would start moving backwards. So the end goal being at some point all of our orders would be available. But it's definitely going forward and then starting to work backwards.
So going forward, you're still going to need to do those redactions. Is the vendor help you set up a system for that, or is it something somebody's going to have to do manually? That's
something that we're going to have to figure out how to do internally. It's not something that the vendor would be able to do for us.
Okay, so that means that a final order might not be up for a certain period of time after it's handed down.
It depends on how easily, well, some cases don't require any redaction, and those could be put up within 24 or 48 hours, depending. Immediately. The ones that need redaction would have to go through a separate process, and depending on what the process is, how complicated that process is, it might take a little bit longer. But it's also imperative that the parties get served with a final order before it's made available to the public. So we have to send it out to the parties pursuant to our court rules, and then we can post it.
What kind of cases need redactions?
Unemployment insurance, public benefits, tax and revenue cases, gun cases. Those are the ones that I can think of right off the top of the bat. We have not completely evaluated all of our case types to determine what's necessary, but we are in the process of doing that.
We also heard a bit about the resource center, which you mentioned in your testimony. There's a desire to have law students or other pro bono attorneys available there. Is that something that you've contemplated?
Yes, we have talked about it. And we have a fellowship program in coordination with Georgetown. I'm sorry. And the fellows are appointed for 1 year, 13-month appointment. And our fellows, our judicial clerks, did volunteer to assist in the resource center. In the course of the last year, we just had a turnover. The prior class ended their term, and we have new class coming on board, and they're being trained as well.
Okay. You mentioned the vacancies in your testimony. So what is the challenge there? Are you not getting applicants? Are there issues at DCHR that are holding up the process? What's going on with those?
Some of our hires do take quite a long time. The process sometimes takes time, more time than expected at DCHR. Sometimes we have not had quality applicants. And a lot of that we're evaluating with the benchmark study. We're evaluating the compensation, because a lot of staff who leave go to other agencies or private sector because they can get more money. And that, I think, is causing a lot of our turnover.
Okay. And so does that mean that you need additional budget to increase the salaries for these vacancies? I mean, what would make a difference there?
I suspect that would make a difference. That's one of the things that we're hoping to find out with the benchmark study. And we are taking steps to evaluate our compensation for our case management group, the legal assistants, legal administrative specialists in particular, as well as the paralegals, to evaluate. They are our lowest paid staff, and where we see the highest turnover.
Okay. Right. I know I was planning to ask you about benchmark today. Let me actually just come back to one other public witness before we dig into all the things that I prepared. We heard from a constituent today, Sam Farber, who participated in the hearing process, and what I suspect is a pretty common adjudication request, receiving a notice of violation for illegal dumping behind his home. He talked through his experience there, and I wanted to start off with, because while we were sitting here, I pulled up the form that the public uses to request a hearing, to answer to a notice of violation or notice of infraction. This may be a little older because it still refers to the legacy DCRA, although I suspect some of the cases you're addressing are still from the legacy DCRA.
If I can, I'm sorry, if I can interrupt you for just a moment. The
Sure.
notice of violation and notice of infractions themselves have the options for a litigant. So each one of the notice infraction, notice of violation says you can admit with explanation, or deny. And then the appeal rights, the instructions on how to file that form with us and what to do about it and how to go through that are actually on the NOV and NOI.
Okay.
The forms that we have in our resource center are for individuals who may have lost that document, or for some reason just don't have it and aren't able to give it to us. So that's a second level of ability to file the appeal.
I got it. So if a member of the public wanted to understand their options, the first place they start is their NOV.
Right.
Okay. So the options are admit with explanation, and deny. Is that correct?
Correct.
Okay. If you believe you are not responsible for the infraction,
Mhm.
what is the most logical course of action?
Deny.
Okay. But that does then require a hearing.
It does require a hearing, and an ALJ pursuant to the Administrative Procedures Act. And ALJ can only make a decision on the liability and a decision on the amount of fines if the ALJ finds an individual liable on evidence that is presented in front of them. So if somebody denies a hearing, denies an NOV or an NOI, we schedule it for hearing so that they can present testimony. Now, I did hear Mr. Farber say that he filed a motion to dismiss. If somebody files a motion to dismiss, the other side has to be given the opportunity to respond to that motion to dismiss. And the ALJ has the discretion to decide whether they're going to make a decision on the papers on a motion like that, or if they're going to schedule it for hearing to hear argument on that. And so if a matter was scheduled for hearing on a denied and then a motion to dismiss is filed, a lot of times the judge will just go forward with the hearing and allow the parties to argue the motion and make a decision on the motion either then or conduct the hearing and make a decision in writing. All of our decisions have to be in writing. Has to be a written decision. So that's the process that goes through. We have to go through.
So in this case, I know you don't have it in front of you, and so we can be a little bit hypothetical about it. But if somebody denies, and then if you just had denied, the ALJ has the opportunity to review the paperwork and then say, okay, you don't have to come in for a hearing. I accept your denial, and I'm clearly not a lawyer, so you can correct my language here. But
generally, the ALJ will conduct the hearing, review the documents, admit whatever evidence, and then make a decision in writing after the hearing. I have to say, I can't speak to cases that are before our agency, and I don't have access to Mr. Farber's case. But I also know that a lot of times, if somebody comes up with documentation that shows that the property is not the same property, a lot of times that will go back to DPW or DCRA, and that evidence will be taken into consideration. And sometimes we'll get motions to dismiss from the agency saying, we made a mistake. We're going to dismiss this in advance. So there's two levels there. There's communication with the agency from the respondent, and then there's a hearing at OAH.
I see.
Am I being clear?
Yeah, you are. What I am unclear on is what the procedure is to send that information back to DPW before getting to OAH, because I feel like in my casework, it's almost always you have to go to OAH.
Our rules require that anything that's filed with us by one party has to be sent to the other party.
Totally get that part. I'm just curious from the consumer side. I'd have to look at his NOV, obviously, but almost always hear from constituents, they don't have and actually from the agency, when we talk to them on behalf of constituents, the only thing you can do now is go to OAH. You can't appeal it with us, which is, for example, at the DMV, of course, you can go through adjudication with them. It doesn't have to come to you. Most of the time, I think it stays with them.
Well, that's because the hearing officers at DMV are embedded in the agency. So this is where you have ALJs who are not embedded in the agency. So the DMV hearing officers are all embedded at DMV. So communicating with the hearing officer is tantamount to communicating with the agency. Whereas we are separate, we are a separate agency, a central hearing panel. And DCRA, for example, does have a whole settlement process that they go through before and have settled cases without having to go through a hearing. So there are other agencies that do that. Every agency has its own process.
Okay, well, that's helpful. You've given me some breadcrumbs here. I mean, in particular with DPW, I've been really meaning to dig in on this and figure out if there's a way to solve some of these before they come to OAH, because I think for members of the public, if they clearly didn't do it and they believe they clearly didn't do it, they're very aggrieved by having to go through the OAH process and take the day off work and say, come on, this isn't my house, you know?
On the other hand, right now, instead of before the pandemic, it really would be taking time off to come down to OAH to have a hearing. Right now, the hearings are remote. And I can't speak to the circumstances of why the hearing that Mr. Ferber talked about didn't actually happen, what happened. I can't speak to those circumstances, and we do occasionally hear about problems with access like that. But for the vast majority of the time, the judges show up, the parties are there, a hearing is held remotely, the judge makes a decision. And so
is it usually like on time, or is there typically a wait, like you have a window?
it depends on the case. The minimum, but there is a minimum because we have to give notice, proper notice, and that's at least 2 weeks. So the soonest we could schedule something after the case is ripe for a hearing is 2 weeks. Now, I spoke at length about the delays caused by a lot of different things. And so there are some case types where there are much longer delays. And that is precisely because of the situation we find ourselves in, increased cases filed with us and decreased staffing. So those delays, depending on the case type, there are longer delays in some cases.
That to me is logical. I guess my question was more so on the day of your hearing. You know, let's say your hearing is scheduled for 10 a.m. Is that really like you're going to be heard between 10 and 12? Is that supposed to be 10 a.m. on the dot? How does that normally play out?
And again, that depends on the type of case. The judge typically takes the bench right about the time that a case is scheduled. Some cases are scheduled with multiple cases at the same time. DPW in particular, our Title 31 cases are scheduled for multiple cases at the same time. There may be some other case types that are scheduled like that. But most of our case types, it's just one case that's scheduled at that time. And the judges do allow a little bit of time before they start the hearing to allow everybody to call into the hearing and make sure that everybody's there. So for the vast majority of cases, the cases start at the time they're scheduled.
And is there an opportunity to communicate to respondents that they may be in a cluster of cases at a certain time if it's a certain type of case?
I'm sorry, say that again.
So is there an opportunity to communicate to the respondents before they show up? You know, you're going to be among 10 cases at this time, something like that, if you're, say, a DPW case.
Generally, the judge tells them that at the beginning, but most of the time they're done very quickly.
Okay.
And again, I can't speak to Mr. Ferber's case.
Right, there was something
I know occasionally we have heard that there have been issues. I really don't know why. Okay. And if I can just back up a little bit to working with other agencies.
Yeah, I want to go back to that too.
I just wanted to say that pursuant to our Establishment Act, when a case is brought before the office, any agency that is a party shall take no further decisional action with respect to the subject matter, except in the role of a party litigant. So
what you're saying is once it goes to OAH, that's where it's going to be.
Yep.
Yeah, that part I get. The thing that I'm trying to figure out is for DPW in particular, if there is an intermediate step that should be available, similar to DMV, where you can send in photos and say, look, see, this wasn't me. You know, you can do that with a parking ticket, for example.
Well, that's the process of denying a plea. And that's the online hearing. The DMV has the same process. It's the same process. It's just embedded in the agency. The hearing officer still has to make a decision based on the evidence that's presented before them.
But the constituent doesn't have to show up for that because it's all done in the office, I guess.
And I can't speak to that. I don't know what the DMV looks like.
Yeah, I mean, that's like, so if you're adjudicating a ticket with the DMV, all you do is upload your response and the photos, and then you wait and hear, which seems like it would cut down on a lot of casework for OAH if it was possible for DPW. That's what I was trying to, that's really what I'm trying to get at. And be less onerous, because I mean, I think the most egregious one that we hear about that really makes people frustrated is, here I live on Lamont Street and I called in illegal dumping in front of my house and got ticketed for the illegal dumping that I called in. And now I have to go to OAH. Right.
And that I think is a process at DPW. And that's one of the things that if we see, and I know that Betsy can probably speak more to the advisory committee, but one of the things that we do is if we see consistent issues, I make a state of the agency report to the advisory committee every quarter, and I will include flag things for the advisory committee and say, these are some things that we're seeing. Is there a way that can be solved? And all of our final orders are served on the parties, which means that the agency gets a copy of the final order. And the judges will identify if there are issues. So,
okay.
And I know that I think it was Mr. Mulhauser who raised a recent case that said that we have a duty to tell the executive branch what to do in certain cases. I just want to flag that the co-decision is a very narrow decision based on a specific law that says exactly that if there's a problem, we can tell that agency that they need to correct their process. But that is a very, very limited. None of the other agencies that we have and none of the other statutes that we apply have that language in them. So the co-decision is actually a very narrow decision.
Noted. Okay. Let's get into the things that I was planning to ask before we heard that great testimony. We've already talked a bit about staffing, but I just want to kind of get this on the record in order, in an organized fashion. How many total employees work at OAH?
We have 103 FTEs, 83 are local, 20 are interagency.
Okay. And the work of OAH involves not just judges, but also case management staff and general support staff?
Yes.
Okay. Can you describe for the committee the different roles and positions that make up the case management and judicial support function?
The case management and judicial support is commonly referred to as our clerk's office.
Mm-hmm.
We have a lead clerk, we have deputy clerks, and then for each of the jurisdictions, each of the clusters, we have a deputy clerk, and then assigned legal administrative specialists and legal assistants. The legal assistants, legal administrative specialists' primary role is to process new case filings, to create the new cases in our case management system, prepare the cases for hearing, send out if the process requires they send out the exhibits, copies of the exhibits in advance of the hearing so that everybody is looking at the same thing during the hearing. And then after the judge makes a decision, serves the parties with the order on the decision. And in the meantime, they also will serve orders rescheduling cases. And they are also our first line of defense for inquiries from the public. So if somebody has a question about a case, it usually goes through to one of the legal assistants in the cluster that they're assigned to that case is in.
Okay. And we talked about the vacancies. This area has the largest number of vacancies. We talked about salaries being a factor. Is that right for this category?
Yes.
Did I understand that correctly? Okay. And then, and you also talked a bit about the impact these vacancies have had on case flow and on the public. So I think we've covered that. we have in your pre-hearing responses that you have 3 ALJ positions that are vacant but never posted. Are these unfunded positions, or are they required to stay open for vacancy savings? What's going on with those?
These are the PFL, 3 of the 4 PFL positions that are ALJ positions. We couldn't post those prior to October 1 of 2022. And to try and distill the issue that we had down, Council in fiscal year 22 gave us the flexibility to use the funds for any purpose as long as we prioritize PFL work for 1 year. ALJs are appointed for a minimum of 2 years with reappointment for 6-year period terms after that. So we could not fill those because of the Anti-Deficiency Act. We would have been begging problems with that. Council gave us flexibility, removed that limitation for fiscal year 22 at the beginning of October 1. We don't have an MOU with DOES for PFL yet. The other issue we have is space. We are bursting to the seams, and we could hire more staff. We just don't have space to put them at this point in time. And we are working very carefully with DGS and EOM to try and figure out what to do about that.
Okay. Well, how much is that holding you back on all the vacancies?
Mostly the ALJ vacancies.
Okay.
But also some of the other, we should be able to figure out some workarounds once we get the vacancies. Most of the vacancies are for positions we already had in the legal administrative specialist. Those are positions that aren't additional positions.
Okay. And adding an ALJ requires what in terms of office space?
The same as all the other ALJs. We need to provide them the same space in terms of size, window access, door. They are lawyers, they have to have doors. So there's that. And yes, we are working with DGS and EOM on space.
And that's all true, even though you're working more remotely.
Yes.
Okay. Okay. When we talked about workload earlier, obviously one part of the equation is staff. That's what we're just talking about now. The other is the volume of work. You got into this a bit in your testimony, but what was the total number of cases that came before OAH in FY22?
In FY22, 21,540 at last count. And I say that because we're behind in data entry for DCRA cases that were our fiscal year 22 cases. And so we expect that number to continue rising at least for a while. And then in fiscal year 21, we saw 15,400. But if I can throw some numbers at you without putting a graph up, in 2016, we saw about 18,500 cases. 2017, 19,800. 2018, 31,800. 2019, 33,100 roughly. And then the pandemic, we saw a dip, and we're going back up. At this point, we're back up roughly higher than we were in 2017, and we expect those numbers to keep rising. So we did see a dip, but we're going back up
again. And you had a pretty big surge in DCRA cases. What do you attribute that to?
More efficient enforcement.
More streamlined,
more inspectors,
process, right?
More inspectors issuing NOIs. NOIs, yeah. So in 2021, we saw 4,000, just over 4,000 cases, and in 2022, we passed 8,000, and we're still going up. So
go ahead.
We're not quite at twice the number, but I would be surprised if we didn't hit twice the number.
And you also had spikes with DPW and Department of Health.
Department of Health went from 204 to 879. And I really don't know. I have not drilled down to understand that completely. DPW is an interesting one because We hit a bottom in 2021 because enforcement was, I believe, slower because of the pandemic. 2021, we saw 4,194, and then in 2022, we're back up to 7,800. But if I can look at, give you some rough estimates. Let me just one moment while I grab this number for you.
Sure.
DPW in 2016, we had about 11,300 cases filed. 2017, 11,800. 2018, 22,000, about 100. Then 19, 16,350. 2020, just over 5,000. 2021, just over 4,000, and we're going back up again. I think enforcement, DPW enforcement is expanding again. And one of the other things is that we created an interface, and this is a project that was in the works since about 2010, I would think, between DPW's computer system and our computer system, so that those cases are filed electronically. We don't actually have to duplicate the work that DPW does by data entry. The cases come from their computer system and into our computer system and are created in our case management system. One of our staff takes a look at them and then sets them on a path for processing. We've been struggling with that system. We put it in place in, I want to say 2021, and we've been struggling with getting it to work properly. So that may also have some impact on it. But I think that this is the way of the future, these interfaces between other agencies, so that the data entry piece that we do, it's much more efficient, but we have to get it to work properly. And that's the tricky part.
Yeah, that seems like it would be ideal.
Yes.
I'm sure a lot of people would find it shocking that you don't already have tech like that, where, you know, you have to have somebody manually entering every case that you get from another government agency. But those of us who work in government and have seen all of the many systems built out over the years are not at all surprised by that information. So back to the FY fiscal year totals, do you expect the number for FY23 to be the highest yet at this point?
I suspect it'll go up again from this year. I don't know if we'll see next year, if we'll see what we saw in 2018 or 2019, but I do expect the number to go up. It's hard to estimate where it's actually going to land.
Top 3 or 4 types of cases that come before OAH?
DPW, DCRA, unemployment insurance, and DOH. Those are the top 4 types.
All right. And I'm pretty familiar with the first 3, and you mentioned you're not exactly sure what the increase around DOH is. So I'd love us to do some work together on figuring that out.
Okay.
Because that's it's an important piece of the puzzle here. Is that rat abatement? Is it, public health?
I do know in the last fiscal year, we did have an increase because of the vaccine exemption denials, that those appeals came to us. I just don't know how big that was.
Yeah.
So
I don't remember it being huge when we were getting our briefings, like how many people have asked for them, that kind of thing. But there's so many things they do, right? I mean, there are citations to restaurants, citations to properties. So I'd be curious to see, is that rat team going gangbusters? That'd be great news, right? It'd be great news. Everybody wants us to get rid of the rats. And if we can make OAH part of the solution, you guys will be heroes. In any case, great. That's very helpful. We'll get into it as we go. So any predictions on, as the public health emergency is winding down, any predictions on the next sort of batch of cases that you think will be on the leaderboard in terms of volume?
I think that we'll continue to see increases in the DOB, in particular, DLCP. Those I think will continue to rise. DPW will continue to rise. I think the jobs report came out on Monday, the federal jobs report came out on Monday and said that unemployment insurance was at the lowest point since 1969. So I don't anticipate in the near future, like the next few months, that we'll see an increase in unemployment insurance cases. That doesn't mean that we won't at some point. And I think that we will start to see increases in our public benefits cases as the federal public health emergency ends and the moratoria on suspension and termination of certain case types. Those will start seeing denials or suspensions or reductions that will be appealed. So we do expect to see more in those case types. I think also possibly rental housing, the moratorium on evictions, I think had an impact on the number of rental housing cases that were filed with us, tenant petitions. So we probably can expect to see an increase in those as well.
That makes sense. Any procedural changes at OAH that change at the end of the public health emergency? We did have an internal suspension of time limits for DOES cases for the unemployment insurance cases. I know council took up legislation regarding that. That's really the only procedural thing, except for our status of the way we hear cases remotely. That definitely we're evaluating that. I don't expect that to change in the near future, but again, it's a constant conversation that we have internally and with our stakeholders about what is the best way to provide access to our hearings. Is it to have audio hearings only? Do we need to start having more video hearings? Do we need to go back to having hearings in person? I think the balance that we have right now seems to work the best for most parties. But there are also things that we need to evaluate. I'm sure we can do things better. We did move quickly to provide the access that we needed to in 2020. And right now we're going back and saying, okay, so we made these choices because that's what we had to do. Can we do this better? Great. You mentioned in your testimony that funds for staffing haven't always kept up with changes to the court's jurisdiction. Does OAH receive special purpose revenue or other transfers from other district agencies?
Yes, we do. We have MOUs with DOES. Those are unemployment insurance cases, and those are federal funds from the Department of Labor. And also from DOES for the paid family leave. Those are special purpose funds.
Okay.
And then we do have some other reimbursements, but they don't go directly to our personnel services funds.
Where do they go?
They go into our general fund and reimburse us for work. And I can't speak better on that, and maybe that's something that we can talk about a little bit later.
Okay. Got it. And is that an MOU? Are those MOUs, those reimbursements?
Those are all MOUs.
All right, so we talked about the paid family leave vacancies. Do you have a backlog right now with UPL cases?
No.
Okay. And then, I mean, council changed the funding stream, so now you're just waiting on an MOU and space.
Right. And the MOU is in progress right now.
And where are we on the space?
We're discussing it with DGS and with guidance from EOM. several discussions about what options we have available to us.
Do you anticipate having to relocate everybody?
I don't know.
Okay.
I would hope not. That would be an expensive proposition.
Mm-hmm. Do you have any idea if there's space in the property you're currently in?
I don't know.
Okay. All right, well, we're gonna follow up with our colleagues in DGS to understand the process there as well. All right, you mentioned the benchmark study. We're finally back to it in my questions. Okay,
right.
we finally, believe it or not, I'm only on question number 4, ladies and gentlemen. Okay, so you're looking at workloads. Is this primarily the ALJs or is it everybody's workload?
It's focused both on ALJ workload and then also staffing workload. And I think that the staffing workload is probably really, really important because a lot of the work that the backup work is done by staff. And that's where we seem to have a lot of the slowdown in our processes. And it's not because staff isn't working hard and doing their jobs to the best of their ability. It's that there's too much work for them to do.
Okay. And what's the procurement process for this study?
We're in the middle of writing a scope of work, which we will submit to OCP and then get bids.
What's your timeline?
We would like to have a vendor selected by the end of February and to begin the process by the end of March and to have a report by the end of the fiscal year.
Okay, right, you mentioned that. So it's February 6th.
Yep.
It doesn't seem likely that you'll have a vendor by the end of the month, if I understand the procurement process accurately. What makes you so optimistic?
We're in the process of writing the statement of work. So that's the report that I've been given, is that our goal is to have one by the end of the month. And it is something that we're working on actively.
And that would be a pretty short turnaround for a procurement, like for an RFP, right?
Yeah. Let me check with staff on where we are. I can't give you a more specific answer than that right now.
Yeah, that's fine. I'm just, trying to manage everybody's expectations here. Unless there's like a very limited number of entities that are able to perform the work, in which case maybe that's the answer. But all right, so let's talk about the case backlog, shifting gears maybe back to where we were in the beginning. A backlog, I just want to make sure we're all clear. So a backlog occurs when cases can't be adjudicated within certain timeframes, whether that's a statutory or a performance related deadline. Is that correct?
Correct.
Okay. The backlogs are mainly with DCRA and DPW cases right now, is that right?
Correct.
Okay. And what are the most common infractions or violations that make up this particular backlog?
Most of the backlogs are cases that are in default status, which means that the NOI or NOV has been filed with our agency and we have not gotten an answer from the respondent during the time that is allotted by statute.
Mm-hmm.
And at that point in time, we are able to issue a final order by default. And we haven't had the number of those cases has increased so dramatically. And I talked to you about DPW going from 11,000 to 22,000. And so that backlog was only exacerbated by having to focus on the unemployment insurance cases and the increases in DCRA. Now, DCRA cases are a little bit different. In addition to the default backlog that we have, we also have cases that, because so many NOIs were filed with us at the end of the fiscal year and beyond. I think at last count, we had 3,000 cases filed between August and October to where we are right now. it just swamped our agency, and we have been having trouble keeping up. And we try to process cases first come, first serve. So first in, first out. And so we're data entry is behind on those. And so we have a chunk of DCRA cases that are behind because of that. And those and we don't know whether they're right for default, whether they are whether there's a denied plea on them, just because we haven't gotten we haven't processed those cases yet. And this is one of the things that our PFL staff, we've reallotted them to help with those. We've spread out the work widely among the agency to try and accommodate those. And if I can just go back, I do have an answer for you on the benchmark study. There are limited entities, so the bidding process should be short.
Okay, that does make sense. So thank you for that clarification.
Yep.
So the DCRA case dump, that's how I'm going to refer to it from August to October. Do you typically see that kind of hustle at the end of a fiscal year, or do you believe this corresponds to the breakup of the agency and them trying to clear the decks?
I can't speak to why DCRA is doing that. I would hate to hypothesize what their process is, but we don't typically see that.
Okay.
I wouldn't be surprised if it was them going through to try and clear the decks to move as the split was happening.
Yeah.
But again, I can't speculate. Yeah, that would make sense to me.
Yeah. Do you ever use temps or anyone to do data entry backlogs?
Yes, we have a rather large NPS contract for temporary work contractors who come in, and that's what we usually assign them to do. The majority of their work is data entry, and I can't tell you how many we have right now, but it's and we have over the last couple of years had a lot.
Presumably we'll see that contract in the oversight response questions, but just in case we don't, we'll follow up with you if we can't find it. But do you know the company that you use for that?
Right now it is Mindfinders. We piggyback on the district-wide contract for temporary service from Mindfinders.
Got it.
I don't know if there's another one or not.
That's okay. All right. We've talked about the IT challenges. We've also talked about.
I'm sorry. I just found out we have 5 temporary workers right now.
5. Great.
Sorry.
No, it's totally fine. It's the live feed here. We love it. We love it. Saves us time later. Okay. So you pivoted really quickly to immediately to virtual during the pandemic, which is I think a great success. So thank you for your efforts in ensuring that people still had access to justice through OAH. What made that possible? I mean, you've got lots of tech challenges that you're still trying to overcome, but how was this pivot possible so quickly? And what did you learn from that makes the agency more resilient?
We learned on Friday afternoon, the March 13th, that we had to go, that we had to.
I remember we had the same moment.
that oh no moment that we all got.
Yes.
We had been, because it was in the offing, and we thought that we would have to do something like this. There was investigation. We understood that WebEx was available to us, and so we exploited that. Got all of our judges a WebEx account, and taught them how to do it. Figured out how to do it and taught them how to do it, and then sent sent everybody home, and then figured out how to create how we needed to work with the papers because our legal support staff was still dealing with papers, and that took a little bit longer to figure out the processes for that so that they didn't have to come into the office. And we have to process USPS mail, which is paper mail, so somebody had to come in. So it was sort of a step process to figuring out, and we know that there are better ways. We don't know what they are, but there are better ways and more efficient ways for us to do what we're doing electronically. Because a lot of what we did in creating that process was mimic the paper process, only mimic it electronically. One of the big changes that we definitely are sticking with is before we were creating paper files, and we were not using our case management system as our official record for the case filings. The pandemic caused us to make that change, which we have been talking about, my understanding is, for years. And it required us to make those changes. And so now we refined that process over the last 3 years. So now eCourt is our official record, and we're working on our file retention policy to bring that up to date as well, so that we don't have to retain any paper. We have checks, something comes in paper, we scan it, upload it to eCourt. There's a double check to make sure that what we got is actually in eCourt. And then once our retention policy is changed, we'll be able to shred that. Right now, we still have to keep the paper.
Okay. Oh, all right. Well, Godspeed.
Thank you.
But we'll obviously stay abreast of that with you and figure out if there's anywhere we can add value through the budget.
Thank you.
System elsewhere. Okay. Anything we forgot?
I don't think so.
Okay. Then
Not from my perspective.
Thank you. Then I shall release you so you can get back to it. Thank you very much for your testimony.
Thank you very much for the time. I really appreciate it. And I enjoyed our conversation.
Me too. Very informative. Thank you.
Thank you.
So now we are going to be joined by the chair of the advisory committee to the Office of Administrative Hearings, Betsy Cavendish. Give us a moment to get her set up.
Good morning, Chairperson Nadeau and members of the committee. Can you hear me? Can I get a thumbs up?
Yeah, can hear you. And I'm going to go ahead and administer the oath to you, and then you'll dive right in. Okay.
Sounds great.
Okay. If you could raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you are about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth?
I do.
You may begin your testimony.
Thanks, and good morning, Chairperson Nadeau, members of the committee, staff, and other witnesses. I'm Betsy Cavendish, the chairperson of the Advisory Committee to the Office of Administrative Hearings, and I'm pleased to come before you today to provide insight into the work of our committee. And congratulations, Chairperson Nadeau, on your new role in overseeing the work of OAH, its advisory committee, and the Commission on Selection and Tenure of Administrative Law Judges, the COST. I will provide an introduction to our work and provide a flavor for some of the issues on which the committee has engaged with OAH, such as transparency, access to justice, vacancies, funding issues, and the like that you've been covering all morning. So the charter or mission of the committee is found in DC Official Code 2-1831.17e, which provides that the advisory committee shall advise the chief administrative law judge in carrying out his or her duties, identify issues of importance to administrative law judges and agencies that should be addressed by the office, review issues and problems relating to administrative adjudication, review and comment on the policies and regulations proposed by the chief administrative law judge, and make recommendations for statutory and regulatory changes that are consistent with advancing the purposes of this chapter. So how we work. Mayor Bowser appointed me to this position in early 2015 as she was establishing her team. It's been an honor to serve and to have the opportunity not only to work with Eugene Adams when he was the chief, but more recently with Chief Judge Curry since she assumed leadership of the agency when Jean moved to head the MOLC, the Mayor's Office of Legal Counsel. The advisory committee also brings the perspectives of other agency directors and general counsels, private practitioners, legal aid, and attorneys from the Office of Attorney General to the Office of Administrative Hearings. And we provide a forum for administrative law judges and members of the public to share perspectives regularly. We meet quarterly, and as I have reported for the past 2 years, we were meeting virtually during the pandemic and have since moved to a hybrid form of meeting. I typically go over to one of the hearing rooms at the Berry Building, and some committee members and members of the public come in person, others participate by video conference. Having a virtual option has been convenient for committee members, just as many litigants before OAH have found virtual meetings to be convenient. To assist the advisory committee in carrying out our statutory charter, the chief gives a comprehensive report at every meeting, and her topics are often a jumping off point for discussion. In addition, we have agency representation on the board, and agency counsel are welcome to attend our meetings, and we try to send notices out through the MOLC to agency general counsel. Committee members help in identifying issues of importance and reviewing issues and problems relating to administrative adjudication. We ask at every meeting whether the chief has issues or problems where she's seeking advice. The committee is fully compliant with the Open Meetings Act, thanks to the collaborative efforts of Lisa Warray at the Office of General Counsel and staff at OAH. I want to just add here that Michael Syndrome mentioned needing a forum for his issues, and he would be welcome to come to the public meetings and talk. We don't try to get involved in case management for particular cases, but if there are issues of general interest, then we would entertain that kind of issue. So now I'll turn to some of the substantive topics we've addressed and raised questions about at advisory committee meetings. Transparency and technology is the top issue. Simply having an advisory committee advances transparency as the OAH regularly reports on key issues to us in open meetings, and these meetings provide a venue for questions. But more than that, one of the main policies and practices that has been a topic of discussion since I began chairing the committee in 2015 relates to transparency. Over the past year, the OAH has continued to make progress with respect to the e-filing of cases, but the posting of decisions online has not progressed, at least to cases being public, although she's making progress on procurements and the like. I know that the agency does share the committee's interest in being sure that the workings of a court regarding agency action are understandable and accessible to regulated persons, agency counsel, other agencies, researchers, the Council of the District of Columbia, and members of the public. This is a critical element of the administrative state in a democracy, and OAH's efforts are still a work in progress. This is in part due to staff changes and tech vacancies, and I understand that there were technical problems with past efforts to build the technical database, and because the time-consuming effort of ensuring privacy must be maintained in matters that are not to be made public or that need redaction. Although, as the chief also noted, I understand that software is available to redact documents quickly and efficiently with quite minimal human oversight. OAH's system of posting some cases on Box through a link on the website seems to have hit a roadblock with the otherwise laudable revamp of its website. More remains to be done, but we are sure that the chief is committed to making a searchable online portal of decisions. Another technological issue that the chief has discussed at meetings that's of key interest to agencies relates to the interface between ticket writers and cases at OAH. And you already discussed this, Madam Chairperson. That project is moving stepwise with tickets from the Department of Public Works moving first, then the Title 31 cases from DMV, then we hope the Department of Buildings Matters. This project is critically important to litigants, the courts, and I would imagine it's an element of transparency too, if the public can see for itself how many tickets have been written, how many matters of a particular type are pending, and the like. Feedback loops. Related to the issue of transparency is what I call feedback loops. The statutory charter for the OAH Advisory Board is focused on OAH itself, but as I have explained to Councilmember Robert White when he held oversight hearings of the committee's work, I see the role somewhat more broadly to place OAH in a feedback loop with the agencies and their general counsel offices so that the government administration as a whole can run more smoothly, accurately, and effectively. Legal cases sometimes arise when there is some kind of breakdown in a program, and rulings that go against the government can and should be a prod to assess whether a program needs fixing or whether the ruling arose from a one-time or idiosyncratic situation. Even one-off situations in cases the government lost may merit agency action. Did an employee act wrongfully or outside the scope of their duties? Is it a disciplinary matter, a training matter, a process flaw? Is there a gap in processes or regulations that was not anticipated and needs to be thought through? One of our committee members is Jed Ross, the head of the Office of Risk Management, another agency that is overseen by this committee. And I'm grateful that he's always willing to stand in for me if I get pulled aside just before or during a scheduled meeting. He and his team have keen eyes for this kind of issue, and it's well positioned to play, and his team is well positioned to play a valuable role in this connection. Of course, we're just an advisory committee without formal powers to command anything, but I think in a limited way we can, should, and do advance coordination and communication among administrative law judges, agency counsel, and agency program officers. Further, the administrative law judges know that they can come to the advisory committee if they are having problems with any agency counsel or how an agency is responding or not to OAH orders. Access to justice. Committee members share the concern of OAH with access to justice issues and the concern that Danielle Burrs articulated in her testimony. Access to justice issues take many forms, from having counsel or advice on legal matters to competent translation for persons of limited English proficiency, to having the website be accessible to persons who don't read English, to being able to get to the hearing physically or participate effectively online, and to having effective service of process. OAH has systems that attempt to accommodate all persons and that help make sure justice is served fairly for all. OAH has the resource center that the committee's previously been discussing this morning to help litigants understand how to navigate the hearing process, as many persons seeking a hearing are not represented by counsel. The new website has many resources online too. OAH hears cases that range from matters like tickets for trash cans that are left out on the street for days on end to complex matters of eligibility for various human service programs. Access to justice issues vary depending both on the type of case and the person who is before the court and their needs. Despite having OAH having systems and programs, sometimes those systems break down, and committee members can let OAH know when there are gaps in their processes generally and when backup systems are needed in the event of one-off breakdowns. I'm pleased that the new website provides resources for persons to navigate online hearings as well as case filings in simple, plain language. But we recognize there's always more to be done, and I think that the Office of Administrative Hearings is always working to make sure to provide access to justice as Ms. Burrs was advocating for, and as I think the chief was describing some of her efforts. With respect to vacancies, we have a standing request that the chief cover vacancies in her report. It always seems to the committee that vacancies for ALJs are filled quickly and postings attract lawyers of distinction. By contrast, sometimes the work of OAH has appeared to us to suffer from some vacancies or turnover on the administrative staff, as has also been described this morning, though I hasten to add the hires that the committee is familiar with are quality hires too. Laudably, the chief is commissioning a study to look at the adequacy of pay and assignment of duties, and we look forward to the results of that study. Funding and managerial prerogatives. One issue that may recur where we've been tangentially involved is in the past relates to funding for the judges. When OAH's jurisdiction expands, when its caseload expands, or when jurisdiction is through memoranda with agencies, the council itself, the OAH itself, and the fiscal and budget teams need to be sure that there are adequate number of judges to handle the matters before it. It's best if OAH funds not be construed to limit the work judges can do to one particular type of case. The chief needs the latitude to assign matters with a variety of factors in mind, meeting deadlines for decisions, spreading workload equitably among judges, building and capitalizing on judicial expertise, and giving judges professional development opportunities to learn new areas of the law. If judges are niched too narrowly, whether through budget restrictions or MOU terms, inefficiencies ensue. We've also been talking a lot about pandemic-related changes for the long term, and we believe OAH will be more efficient and effective as a result of pandemic-related moves to more telephonic or video hearings. Inspectors or other government witnesses will be able to tune in for their testimony and not spend transportation time getting to 441 or waiting for multiple cases, some of which they may not have been the inspector on or the witness for. Rule changes. The advisory committee has not been consulted on any proposed rule changes this past year, but we stand ready to help out if OAH moves to amend its rules in the coming year. And in conclusion, through Judge Curry's leadership and partnership, there is open dialogue and collaboration to address issues of concern. I believe the committee is operating efficiently and effectively to fulfill its statutory mission. And I think I speak on behalf of the committee members in affirming that we stand ready to support the chief and the rest of her team as best we can through our advice, connections, and experiences. And I look forward to answering any questions that the committee may have.
Thank you very much for your testimony. I don't have a lot of questions for you, but I do want to hone in on a couple things. One of your priorities is to review issues and problems relating to administrative adjudication and provide feedback to improve agency operations. Where do you think you've been able to have the biggest impact in that area, with which agencies?
I'm not, one from the past year isn't necessarily coming to mind, but several years ago when some of the human services functions were being, the technological database was being migrated over, there was a tech problem whereby some people were not getting noticed about changes in their benefits or cessation of their benefits. And as a technological system, I think the tech folks were thinking, oh, we're getting 98% out, but 2% of violation of the constitutional due process rights wasn't good enough. And so when we see things like that, I think we were able to play a role in highlighting the issue to the tech folks that we've got to get to 100% here because it's a constitutional requirement. I'll give that as an example.
Just the pesky old Constitution. So we had a lengthy discussion. We went really far into the weeds about, for example, the process for an NOV with the Department of Public Works. And I'm curious if you were probably listening in on that, but essentially,
Yeah, I heard Mr. Farber's testimony. And
like why can't it be just as easy as adjudicating a parking ticket, right? So that's the thing is I'm wondering is how do you take what you're seeing and draw conclusions and think about streamlining things that both could help the resident, respondent, or OAH, or both? And are there other, maybe DPW isn't, maybe that's not rising to the top of your inbox as much as it is mine as a Ward 1 council member, but what are some other places like that you think?
Well, I think it's a great question. And, I think that the earlier a hearing is assigned, when someone denies an NOV and doesn't just pay a ticket or something, then they say that wasn't me, that wasn't my house. The earlier a hearing is assigned, then the lawyers at the agency will, if lawyers are covering the OAH, then they'll look at the file, see like a motion to dismiss or get ready for the case and be like, wait, we've got to voluntarily dismiss this. So if it hangs out for a long time, then people like Mr. Farber are anxious because they have something hanging over their head that accuses them that they did something wrong, or the person that you mentioned who calls in illegal dumping and then gets a ticket for being an illegal dumper. Like that should get resolved really, really fast. And I think it'll happen. I think that's much more likely to happen the sooner OAH sets it down for a hearing, even if it's double booking it like an airplane where they can't actually know they can't have all those hearings on that day. I think it'll get the attention of the agency sooner.
Mm-hmm.
So that's one.
Yeah.
That's one way to do it. I think litigants sometimes, people in that situation sometimes go in multiple directions too, and are they may complain to their MOCR that they got a ticket, and the Mayor's Office of Community Relations and Services can talk to the constituent affairs people. And we try not to get involved really in individual cases. Like the Mayor's Office is not the adjudicator for all the decisions in the district, but sometimes it's appropriate to say, hey guys, could you have a second look at this matter? It sounds like we got a problem here.
Yeah.
And we never try to command a result, but we may say like, hey, could you have a second look? And hopefully that kind of avenue too could result in a voluntary dismissal by the agency and a correcting of the errors. And I do think that there are ways that we should be able to address those errors. Now, lots of times there's just a good faith disagreement over whether something's a violation or not. So, those are going to be longer hearings and take more time. But I am not aware of the committee hasn't had anything brought to our attention that DPW is systematically making errors of the sort where it's ticketing a house that isn't owned by the person that it named on the ticket. I'm not aware of that, nor am I.
That one was newer for me, although I think I've heard it at least once before.
Mm-hmm.
The other thing where you're the one who calls it in and then you get the ticket, I think we've heard a lot about, and that's really challenging. Because it seems like the ticket writers maybe don't have access to the full complaint or whatever, right? Because if you did, you would look at it and say, wait a second, right?
I called that in, right?
Yeah, exactly. Like this isn't some really diabolical effort to get your bulk pickup quicker, like
right.
So
that's a good one, and it merits us thinking about whether there needs to be a new field on like the 311 intake that goes over to the agency, that like the agency in sending out an inspector knows, don't ticket this person, just verify that there was dumping there, or go through the material dump to see if you can see
let the environmental craft people do their job and get it. But and a lot of people don't realize, because we in Ward 1, the illegal dumping we're dealing with is a lot of times like household trash. But there's other parts of the city where illegal dumping is like appliances and tires and real environmental hazards, and there's a whole team of people that go after those folks. And that's actually all right, we're in the wrong hearing for this, but see, I'm gearing up for DPW. Okay. So but back to our work here, Chief Judge mentioned a report issued annually that sort of reviews what they're observing and perhaps makes recommendations to different agencies. I think is that something that you all work on together? Is that?
No, she does that at our meetings. She often gives a report that I've requested on significant case decisions, and then that's a helpful way of her filtering out what's significant, because we can't just look at posted decisions because they're not, by and large, not posted. And she has more ability to say what's significant. But to your earlier question about why that's important, I do think it's just kind of a fundamental principle of law and the administrative state that cases should be treated alike, and there's no way of telling whether one particular judge judges something one way and another goes another way, or if you're thinking about contesting, you can't look up and see like who's been in my situation before. Did they win? What were the arguments that the court found compelling? And oh, that was in my case too. Or oh, I don't have a leg to stand on here. It looks like every one of the people in my situation loses, and the agency is allowed to do what it did.
Right.
Or,
Right. Because right now it's sort of just like word of mouth. Like if you happen to be represented by an attorney, that person probably knows what's been going on at the court, but or at OAH, but
maybe depends, like if you're a repeat player, if you're lucky enough to have someone at legal aid, they probably have colleagues who've litigated similar cases before.
Right.
But if if you're starting up your own law practice and you want to help people in their dealings with the government, how are you going to know whether your client's likely to succeed other than simply by looking at the statute and the regs and that straight up reading of the law?
Right.
But you won't know how the disputes come out. And so it's critical. I think it's critically important. And I know that the chief agrees. It's just, there are so many things to do and cases to attend to. And you heard about the workflow and the workload there. It's gigantic. And they're just a couple of trains going like, let's get these cases decided, or let's get that backlog addressed. And we've got to figure out the transparency issue, but it's been hanging out there for a long, long time.
Yeah. Well, and I just, urge you all, like, it sounds like you're already thinking this way, but just to be thinking about how to advise district agencies on things they could be doing differently if, when you're seeing trends. And I that's what we obviously seek to do here through our oversight at the council. But sometimes it's better received from the executive to the executive. So,
I think council member that Molk, that's part of Molk's role too. They have associate counsel who have a range of agencies that they work with, and they get significant matter updates from their agency general counsels, and they work with the agencies, and they're in a good position to say, hey, we're getting nailed on, something's going wrong here. So there are lots of us who are devoted to the same issue. I am not at all, Mr. Mulhauser said something like Mayor Bowser isn't interested in that. And I don't know where that came from. We are, of course, interested in fixing problems in the government and preventing problems and not having people have to go to OAH for a hearing if they were wrongly ticketed or whatever. But and also if there are repeat malefactors who are endangering their tenants' housing conditions or something, that we're seeing the same people again and again. Are there other remedies besides at OAH that should be invoked? Like when does it rise to a criminal referral or that kind of thing? So I think there are lots of us who are very concerned, whether it's risk management, the agency GCs working with the program people, the agency directors, the OAH advisory board. OAH is a very unique place that sees, friction in the workings of government. And lots of us are interested in where that friction is. And if there are problems, and let's fix problems. We're all about fixing the problems. That's what we want to do. I'm sure.
Well, and I would say the intersection of things that you just mentioned, MULC, ORM, OAH, and then, constituent experience, there seem to be a lot of levers to make government work better, whether it's the risk of legal action, the risk of liability, ensuring people's constitutional rights are upheld, or just better customer experience. So, I think in this committee, we're going to have some opportunities to draw those connections. So I'm very excited about that. Just a couple more questions for you. Do you have any thoughts about how we can strengthen the resource center online for pro se litigants?
Oof. I think that they have nicely gone over. You can kind of hit the agency you're interested in and learn a little bit more about that. Maybe sample pleadings are useful or more reassurance that it's not as, it's not quite as formal a forum. You don't need to be scared if you're not a lawyer in stating your case, but some people would feel very reassured perhaps with some sample types of pleadings, like even if it just has a block that says insert what happened to you here, or tell your story here. People might feel like, oh, okay, good, I can do that.
And how does the commission approach the language access challenges that we face? Right now, I think what we're seeing is only Spanish and Amharic languages offered as translation on the OAH website. Is there a need to add additional languages? What are you seeing?
I think that I defer to the Office of Human Rights' assessors about whether it's rising to a threshold where they need to have more languages on the website rather than on a as requested basis.
All right, we'll follow up on that. That is all I had for you.
Okay, thank you, council member. Bye now.
Thank you very much. And this will conclude today's public oversight hearing. If you plan on submitting written testimony for the record, a link will soon be added to my website at brianneknadeau.com/committee, where you'll be able to upload your PDF or Microsoft Word file. The record for this hearing will close at 5 p.m. on Wednesday, February 8th. I'd like to take a moment to remind you the Committee on Public Works and Operations will be holding 5 more performance oversight hearings. This Thursday, February 9th, the performance oversight hearing will be held in the Office of Human Rights and the Commission on Human Rights. Next week, we will be holding performance oversight hearings on the Department of For-Hire Vehicles and Department of Public Works on Wednesday, February 15th. Additionally, on Thursday, February 16th, this committee will join the Committee on Transportation and the Environment to conduct a joint oversight hearing on the Deputy Mayor for Operations and Infrastructure. Finally, on Wednesday, February 22nd, the committee will hold performance oversight hearings on the Office of Contracting and Procurement, the Contract Appeals Board, the Office of Chief Technology Officer, and the Department on Licensing and Consumer Protection. If you'd like to testify at any upcoming Public Works and Operation hearings, you can sign up on my website at brianneknadeau.com. The time is now 11:59 a.m. and this hearing is adjourned.